Hello everyone, myself Anjali. Today I'll be presenting a presentation on topic terrorism. Terrorism can be broadly defined as the use of violence or threat to intimidate or coerce, especially for political purposes. While the term terrorism is not explicitly defined in Bharatiya Nyaya Samhita, several special laws provide detailed definitions of it. When we say about legal definitions, there is no such legal definition of the term terrorism, but the term terrorist act has been defined under section 15 of the Unlawful Activities Prevention Act 1967, also known as UAP Act, as whoever does any act with the intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with intent to strike terror, or likely to strike terror in the people or any section of the people in India or in any foreign country by any harmful means. Now, the next topic is legal framework. India's primarily anti-terror law is the UAPA, which has been amended multiple times, notably in 2004, 2008, 2012, and 2019, to strengthen its provisions. Some key aspects includes Section 16 Punishment for Terrorist Acts, Section 18 Conspiracy and Attempt to commit a terrorist act, Section 35 and 36 Power to designate individuals and organizations as terrorists. There are other relevant laws as well, which are Bharatiya Nyaya Samhita Section 150, 152, which are waging war against the state, sedition. National Investigation Agency Act 2008 establishes the NIA as a central agency to investigate terror related crimes, Arms Act, Explosives Acts, and other. Landmark cases. Several cases have shaped India's anti terror jurisprudence. There is a well known case which is Ajmal Kasab case 2012. It was the worst terror attack in the Indian history and a well known case or attack to all the people of India. Mumbai attacks trial showcased the efficiency of anti-terror laws and speedy trial under UAPA. There is another case which is KA Nazib Wasi Union of India 2021. The Supreme Court emphasized personal liberty, granting bail despite UAPA charges due to prolonged incarnation without trial. Criticism. Stringent bail provisions. Section 43D, subsection 5 of UAPA makes it very difficult to get bail. This essentially leads to pre-trial punishment, especially since trials often take years. Now, the another criticism is vague and broad definitions. Terms like unlawful activity or terrorist act are broadly defined, allowing wide discretion to the executive. This may also result in criminalization of dissent, activism, or even criticism of government. Prolonged detention without trial. UAP allows detention without charge sheet for up to 180 days, which is like 6 months, which violates the standards of speedy trial under Article 21. Designation of individuals as terrorists. After 2019 amendment, the government can declare an individual as a terrorist without a trial or judicial process. Lack of accountability and oversight. The executive, that is government, has been unchecked powers including in arrest, investigations and assess seizures. Thank you.